an appeal in the matter of claim on the application of Fiske and Test Valley Borough Council and another.
Thank you.
My lords, good morning, my lords. May it please you, I appear on behalf of the appellant. My name is Burton. The appellant, the claimant below. My learned friends, Mr. Green and Mr. Williams, appear on behalf of the respondent, the defendant, local planning authority. My lords, the interested party does not appear and has not appeared throughout. The appellant, Mrs. Fiske, is in court, as are both parties instructing solicitors.
Yeah.
Just in terms of housekeeping, my lord should have a court bundle, a supplementary bundle. Of course, the court has, amongst other things, our replacement skeletons and the judgment below, an authorities legislation bundle, and one additional item which we at the bar believe might assist my lord. I've prepared an enlarged set of plans and drawings because some of them were quite hard to.
You're going to take us through those, are you?
I will, my lord. Yes, of course.
Right. Thank you. Thank you for doing that. It may be that they're very helpful to us.
Yes. Let's see, my lord.
In an ideal world, it might have been nice to have one of these plans a bit earlier. So I must say, speaking for myself, the ones in the bundle are incredibly difficult.
Noted, my lord. Yes. My lords, I propose to begin with an introduction, and in the process, I want to touch on the overarching test that I for mandatory materiality.
Before you start, if I may, there are two other things, perhaps by way of housekeeping, but which I think we would feel benefited by having. One is the actual grounds of appeal, which I don't think have found their way into the bundle. It would, I think, be helpful just to see those. I appreciate the way in which the case is presented is if you like, a compendious approach. But I think as a matter of form, at least we ought to have the grounds. That's one thing. The other thing, which I think we feel we might benefit from having, is the objection actually submitted by or on behalf of Mrs. Fiske. That's to say, the relevant objection or objection letters pertaining to this particular decision process. Appreciate that there will presumably have been others because there's been quite an active planning history in this case.
Yes. Yes.
Is it not necessarily straight away, but perhaps in the course of the day?
In the course of the day, I'll do my best, my lord. There has been a very active planning history, and
there has. But in the committee report, there are two passages which may, I think, represent Mrs. Fiske's objection, but I'm not sure, and I would like to be sure.
Right. Well, my lord, perhaps we can try to find that over the short adjournment.
Yes. Well, I hope that won't cause inconvenience, but it would help the court if we could have those.
Right. Okay. Well, obviously we'll do our best. My lords.
Yes.
Apologies that the grounds are in the.
Well, it hasn't caused us any, I think, material inconvenience, because we have understood, of course, the arguments as put in the skeleton argument, and both sides have proceeded on the basis that the issues are understood and agreed as being the issues.
Yes. If it assists, what I did, my lord, and I know, strictly speaking, I'm not meant to do this, but I just find it helpful, as I actually repeated the grounds in my skeleton argument. So
right. So they're all.
So they are
one way or another represented there.
They are all. They're set out verbatim.
Oh, I wonder whether they were set out verbatim or paraphrased, but I mean,
they're actually set out.
Probably verbatim.
They are verbatim.
Right.
Thank you.
Yes.
That has helped us already then.
Okay. I'm grateful. So, as I said, I'm going to introduce matters, and in the process, I want to touch on the test that lies at the heart of this challenge, which is the mandatory materiality test found in Samuel Smith. And I'll also explain how I propose to structure things thereafter. So, subject to judicial question or intervention, I anticipate my submissions will take me to the short adjournment, possibly a little beyond. As my lords know, this is an appeal against the learned judge's refusal of a claim seeking judicial review and quashing of the decision of 24th of May 2021 by the local planning authority, granting planning permission for a sizable district network operator or DNO compound and some accompanying solar panels on about 6 hectares of land, and I'll call that the 2021 permission as I have in my skeleton. We have the decision notice in the core bundle at tab 13, and it's followed by the report setting out the authority's reasoning. The primary purpose of the 2021 permission was to allow a solar farm on the land over about 72 hectares, granted planning permission in 2017, that I'll call the 2017 permission solar farm. The primary purpose was to allow the 2017 permission solar farm to connect to the national electricity grid via the DNO compound, the subject of the 2021 permission. And we have the 2017 permission notice in the supplementary bundles at 5 and various plans and drawings, which we'll come to. As my lords know, at the appellate permission stage, Lord Justice Newgee boiled matters down to a question that we have both quoted in our skeletons.
Yes.
Was the fact that the 2021 permission was incompatible with the 2017 permission, and hence that there was a risk of breach of planning control, something that was so obviously material to the 2021 permission as to require consideration. Now, the question, of course, does require a lot of teasing out and elaboration, not just because by 2021 permission there is meant the application for that permission, but also because, as I say, as I did below, that the incompatibility and the risk of a breach of planning control were independently mandatory material considerations. But certainly the question works as an encapsulation, and in my submission the answer to it is yes, both the incompatibility and the consequential risk of a breach of planning control were separately mandatory material considerations to which the authority should have had regard, and respectfully the judge below was wrong in finding otherwise. But as the authority did not have regard to the incompatibility, the permission stands to be quashed, and similarly as it didn't have regard to the consequence. Now, I'm very conscious that this court is well, or members of this court are well versed in matters of planning law, and I've tried to tailor my submissions accordingly.
Not all of them, I'm afraid.
My Lord Henderson, I noted that, and I've tried to ride the two horses, as it were, to set the overarching test for that's at the heart of the challenge. Could we please just turn up the Samuel Smith case, which is the authorities bundle, tab 6.
Yes.
And this concerns mandatory material considerations. We don't need to spend time on the context. Of course, it is a case that concerned the town and country planning system. It specifically concerned greenbelt considerations. I know it's very familiar to my Lord Lindblom from its time in this court. The judgment of Lord Carnwath is the sole judgment, and the relevant paragraphs are sidelined, and they start at paragraph 29. This is at page 141 of the authorities bundle. Whilst I'd invite my lords, if my lords haven't done so already, to read through paragraphs 29 to 32, the nutshell is very neatly captured at 32. And if I might, I'll read the words, picking up partway through the paragraph, because
would you like us just to read that to ourselves, for ourselves?
I would, my lords, if yes, please.
Do you want us just really to focus on paragraph 32?
I really do want you to focus on paragraph 32, because in my submission that is the encapsulation.
Thank you.
And it's the words that one can insert in the second sentence after inspector, that one can insert the words something is a mandatory material consideration if it's expressly or impliedly identified in the act or the policy as considerations required to be taken into account by the authority as a matter of legal obligation, or alternatively, wherever on the facts of the case they were so obviously material as to require direct consideration. And I've referred to those as Lim 1 and Lim two in my skeleton, and I'll stick with that.
Yeah.
Now there is a gloss for planning cases, in that one does of course need to also bear in mind what is in fact the prior step, which is what may be a material consideration in planning.
Mm.
And of course one isn't there talking about what is a mandatory material consideration. One's talking about what is lawfully capable of being material in the planning context. But inevitably that first step then feeds into the question of mandatory materiality. And for that, could my lords please turn to tab 8 in the authorities bundle, which is the Westminster City Council and Great Portland Estates case.
Yeah. Thank you.
And again, and I would say again, that of course this is a case concerning town and country planning. The facts which appear from the head note can be fairly briefly stated. It concerned a policy to preserve certain long-established industries in central London, in the city of Westminster, and what the House of Lords did. The challenge was to the policy. They applied the same test to whether a matter was a material consideration in the preparation of a local plan, which is where this policy had cropped up, as in relation to the grant or refusal of planning permission. And they held the policy was concerned with a genuine planning purpose, the continuation of an industrial use important to the character and function of the city, and so was lawful. But it's again, it's the principle that matters, not the particular factual context. And for that, please, could we turn to what is in Authorities Bundle, page 175.
Yes.
And this is the speech of Lord Scarman, and here we see at about C the words "the test, therefore." The test, therefore, of what is a material consideration in the preparation of plans or in the control of development. This is referring to a predecessor act, of course, in respect of planning permission. Reading on is whether it serves a planning purpose. Reading on, and a planning purpose is one which relates to the character of the use of the land. And this principle now has the authority of the House. But also, and potentially importantly, reading down the page to E, however, like all generalisations, Lord Parker's statement has its own limitations, and Lord Scarman lists what seems to be a non-exhausted list of features that are not to be ignored, and essentially, and if my lords could read that, but essentially the point is there's the general rule, but there will also be exceptions to the general rule, and in those exception cases, these other considerations which might not go to the land use, the character of the use of the land, may also be material considerations in planning terms.
Yeah.
Yeah. 174 page. Yes, thank you. 174. And my learned friend, Mr. Green, would invite my lords to look at 174H.
Yeah.
And I believe the words there picking up in the course of his judgment, with which the other members of the court agreed, Lord Parker Senior said that when considering whether there has been a change of use, what is really to be considered is the character of the use of the land, not the particular purpose of a particular occupier. Thank you. So there is, in a sense, a response to that in Lord Scarman's exception. I should say I'm not in any way, the exception is in no way my primary case here, but I'm drawing attention to it. Now, in my submission, my lords, the appellant need only satisfy you that the incompatibility between the development applied for here and the 2017 permission was obviously material for the appeal to succeed. I do, of course, invite a further positive conclusion in relation to what I've termed the consequence of the grant of the 2021 permission, namely the real risk of a breach of planning control. But I say I shouldn't need that to succeed. And as regards the incompatibility, in a nutshell, the incompatibility, it was obviously material because the particular justification for the planning application here and the planning authorities aligned reasons for granting it made it so. In essence, that the 2021 permission was necessary to complete the 2017 permission solar farm by connecting it to the grid. And that was why the authority concluded it complied with restrictive planning policy and so was granted permission. And I say that whilst all cases turn on their facts, this case does so quite intensely by reason of those fundamentals necessarily set in the context of the statutory planning regime, because the incompatibility simply contradicted the authority's reasoning for granting the permission. And as I'll explain here, the facts were really quite unusual. The consequence, of course, sits in and flows on from the same factual and statutory matrix, but with some additions. Of course, this court is, I suppose, a judicial review with evidence in writing, and this court is at no disadvantage to the learned judge below as regards the evidence. It's in the same position. As to why, by way of introduction, the learned judge went wrong, I say with great respect to him, first and foremost, he lost sight of the particular facts of this case and their importance to that question of mandatory materiality. And he did so, at least in part, I say, because he became distracted by matters that were not in evidence before the authority at the time of its decision and formed no part of the authority's reasoning when it's made its decision to grant, and in fact, as I say, contradicted that reasoning. And I refer now specifically to my learned friend's arguments regarding the so-called other options open to the interested party or another developer. And so the judge lost sight of the importance of why the application was made and why the authority decided it was policy compliant, and so why the permission was granted. He lost sight of the importance of all of those to the question of mandatory materiality. And he did so also apparently falling into some confusion. It's not entirely clear on the judgment, apparently falling into some confusion as to the ambit of what may be a material planning consideration, because he does seem to have adopted an incorrectly narrow approach to the rubric serves a planning purpose and relates to the character of the use of the land, and also made no acknowledgement or allowance for the possibility of exception cases beyond that rubric, and that then fed into and infected his approach to the related question of mandatory materiality. That's all under my grounds 1 and 2, and my ground 3 I will deal with if I need to separately and shortly at the end. So in terms of a structure of my submissions from here on in, what I propose to do, and this is under grounds 1 and 2, is I propose to first address the relevant statutory planning framework and what I believe are uncontentious principles of planning law, and I'll try to ride the two horses, going as swiftly as I can, my Lord Henderson, through the planning principles, but not so swiftly as it were. I suggest I will spend a little time on the rule against the use of physically incompatible planning permissions, because that is clearly an important point in this case. That was most recently, of course, and authoritatively considered by the Supreme Court in Hillside. I'll come to that. Then I'll come to the facts, and I'll start to explain why I say not just that my case for mandatory materiality is correct, but also where the judge, I say, went wrong. And I'll then consider what the case law says specifically, because it does say something regarding mandatory materiality in the case of incompatibility, like this, and then in particular that's the Pilkington case, and I'll develop my arguments in that way. What I propose is something of a canter, some planning law propositions or principles. Now, the planning system is a self-contained statutory code. Its principal act is the Town and Country Planning Act 1990. It revolves around the fundamental concept of planning control, which has two foundational principles. The first is that development, which is defined by section 55 of the Act, requires planning permission, and the second is that development done without planning permission may be, doesn't have to be, but may be enforced against. Unless planning permission for development is granted by such as a general development order, it is to be obtained by an application made to the local planning authority, which is then the subject of statutory consultation before a decision is reached, and the authority is required to hold a planning register that contains, amongst other things, applications, their plans, drawings, and the record of their determination. And we have all of this in the legislation authorities bundle if need be. The specific provision there is Article 40 of the Town and Country Planning Development Management Procedure Order 2015, which is at pages 73 and 74 of the bundle. We need not turn it up, I suggest. When a planning authority is considering whether to grant planning permission, it must have regard to the statutory development plan and to other material considerations. The statutory development plan has a rebuttable priority in that the decision is to be made in accordance with the development plan unless material considerations outside the plan indicate otherwise. This is all trite. As my lords might imagine, there is little, if any, dispute regarding the principles of planning law at the bar, but there are some caveats to what my learned friends say, and one concerns what they say at paragraph 10 of their skeleton. Could my lords please just turn that paragraph 10 up, please?
Can we put the authorities on?
Yes, my lord, of course, thank you. So, as to that, whilst the question for a planning authority is considering an application for planning permission is whether the proposed development is acceptable in planning terms, of course, within the statutory test that I just set out, rather than what motivates the applicant, at least generally in any event. There might possibly be exceptions regarding the applicant's motivation, conceivably, but I don't say that's this case. But the caveat is that, of course, the rationale for the application may be obviously material, and there may be no material difference between that rationale and the applicant's motivation. I make that caveat there.
Yes, I mean, I think there are probably dicta to that effect or implying that in Sage, aren't there? Which I think is one of the cases that you refer to.
It is, my lord, although clarified, of course, by Hillside.
Well, there's a recent case in which that was done, yes.
Yes.
But I'm not sure that that's of central significance
No.
to your argument.
No, it isn't, my lord, no. Just continuing through the propositions, of course, as I say, development done without planning permission may be enforced against, and I've set out the relevant statutory provisions in the Act in my skeleton. They're in the bundle. We need not turn that up. Further, a person may apply for as many planning permissions for the same land as they wish, whether they are different or compatible or not. They need not have an interest in the land to apply. They must only, there's a procedural requirement they have to satisfy, they have to notify the owner or owners, but they need not have an interest in the land. And generally, at least, planning permission runs with the land. There are exceptions, for example, a temporary permission, or indeed, if permission once granted is then lost through failure to begin it in time, or potentially if the authority serves what's called a statutory completion notice. There's no obligation to use a planning permission, and subject to anything in the permission itself or an accompanying planning obligation under section 106 of the Act. There's no obligation to complete development under a permission once begun, though it is of course possible to lose the ability to build further if for example, a statutory completion notice is served. To keep a permission alive, one must begin it in time, which is usually now, by statute, 3 years from grant, by beginning a material operation comprised in the development. That's section 56(2) of the 1990 Act. Just a point here, because there's certainly scope for some confusion. My lords might note that the word implement in planning is often used, but it's used in different ways, and so rather confusingly. Sometimes the word implement is used to describe the section 52 subsection 2 act of beginning a permission in time. But that's not the statutory language. The statutory language is beginning a material operation comprised in the development. And it's confusing because implement is also sometimes used to mean fully or at least substantially completing development under a permission. And I flag that because it crops up fairly regularly. And indeed, in this very case, we see an example of this at paragraph 4 of the judgment. And my lords could just look to that. Paragraph 4. I only offer this by way of example, but at paragraph 4 we see the judge first of all use the word implemented in the first sentence clearly to convey and mean the 2017 permission having been begun. And then in the second sentence, it's unclear what he means by implementation as regards the 2021 permission. In any event, I will endeavour to steer clear of potentially confusing use of the word implement. Make that point. Not only just continuing then. Not only may a person apply for inconsistent permissions, a planning authority may grant inconsistent permissions for the same land, but there is very important in this case a procedural decision-making process caveat to that, which I will come to, but after the facts, and that's touched on specifically by Lord Widgery's obiter regarding special cases in the case of Pilkington. I come to the rule against using physically incompatible permissions. I'll just spend a tiny bit of time on this because there is a further principle. One may not actually build out physically incompatible permissions lawfully, build them out. And it sounds obvious, but it's a rule that's an example of the courts having to fill a gap in the statutory planning code, and it concerns the eventuality of an attempt to use a planning permission that's physically incompatible with an already used or indeed potentially merely just begun planning permission. Now, for a long time, the leading case on this was Pilkington in the Divisional Court, which was approved by Pioneer Aggregates in the House of Lords, and much more recently confirmed and then explained by the Supreme Court in Hillside. And I know this may be familiar territory. If I may, for this, I would go directly to Hillside, not least because the facts of Pilkington are rather convoluted, but so far as relevant, are very neatly captured in Hillside. So Hillside is at tab 4 of the authorities bundle. And
yes,
I will use Hillside first to just explain the relevant facts of Pilkington, because that's just genuinely more efficient. For that, it's the sole judgment there is given by Lord Sales and Lord Legate. And for this, perhaps we could turn to page 95 of the authorities bundle and paragraph 29. And this really does clear up what can be quite a confusing presentation of the facts in Pilkington. Yeah. Reading to the words, the owner of a plot of land was granted planning permission to build a bungalow on the plot. After that bungalow was built, he discovered an earlier planning permission granted the previous owner to build a bungalow on a different part of the same plot of land. The description of the development in the earlier permission and the relevant plans show that it was contemplated that the rest of the plot would be used as a small holding. So that's the earlier permission. And the question was whether the landowner could lawfully build another bungalow in the location specified in the earlier permission. And the divisional court held not. And if my lords could perhaps read paragraph, well, I'll come back to paragraph 30, which actually concerns the point regarding process and procedure and decision making in the case of incompatible applications and permissions. But paragraph 31 it explains the distillation of the Pilkington ratio on the Pilkington fact. Now, quite simply, having regard to what had been built pursuant to the later permission, this is around H at that page, the development contemplated by the earlier planning permission could not be carried out because the earlier permission wasn't just the building of a bungalow, but the building of a bungalow in a small holding. Now, the facts of Hillside are they are very convoluted. Of course, this is a case that's extremely familiar to my own friend, Mr. Green, who appeared for the claimant appellant throughout. But they are sufficiently set out in the head note to Hillside, and also paragraph 18. Could my lords please turn first to the head note at page 86 in the authorities bundle?
Yeah.
And we start just above D. So here in 1967, the then planning authority had granted a planning permission for a housing estate comprising just 401 dwellings and a road system on a large site, and that was all the subjects of a master plan. Later, and there's a very convoluted history that we need not go into, but later further permissions were granted and they were built out for individual houses that were inconsistent with that original master plan. And that meant that the original permission could not physically be completed. Now, it's an important point in Hillside, it's important to our case, that there was plenty of the site left over that could still be developed in accordance with the original master plan. But the planning authority told the developer it had to stop building under the original permission as it could not physically complete the original permission in accordance with that master plan. Now we can see the developer's argument, and the reason I say that paragraph 18 is quite important. That's at page 93. We see this. So the first instance judge accepted that much of the site is unaffected by this further development, that the further development being the development under the inconsistent permissions, in the sense that it will still be physically possible to build houses and roads on much of the site which conform to the master plan. The developer contends that on a correct legal analysis, further development on these vacant parts of the site may still lawfully be carried out pursuant to the 1967 permission, and that the courts below were wrong to hold otherwise. Now that submission was rejected again by the Supreme Court. Now, turning back to the head note at this point, if we may, the developer's fundamental argument in Hillside that's relevant to this case is the argument that's captured at F at Roman 2. Unless it expressly said otherwise, a planning permission for the construction of multiple buildings was properly construed as permitting the construction of any subset of those buildings. There's no reason why the landowner could not combine such development with development on other parts of the site authorised by other planning permissions. So that's the paragraph 18 I've just taken, my lord, to a slightly fuller encapsulation of the point. And the court's response to that is at 1 and then 2 in the head note. But I'll go, if I may, to the detail of that in the judgment. So, could my lords please turn to page 98?
So what mattered was the departure from the master plan, which is summarised at 6 and 7 of the judgment. They found an old quarry, so they had to build their houses somewhere else. And then there were other, they were called variations, but there were other ways in which they departed from the master plan that got shut.
Yes, my lord. Yeah. Yes. So, if my lords please turn to page 98, and could I, with apologies because it's a fairly long section, but it's paragraphs 41 to 45 that I would invite my lords to read.
Well, we'll read through those paragraphs.
Thank you, my lords. Sorry. My lords will note, please, that when Lord Sales and Leggett say at 43 at the bottom, what must be shown is that development in fact carried out makes it impossible to implement the second permission in accordance with its terms. It implement there is used in well, it appears to be used in the sense of completing the second permission. Certainly that is my reading of it. But as regards what is said at 43 and then again at 45, the test being whether it's was physically impossible to carry out development authorised by the terms of the unimplemented permission. Carry out there means carry out in full, and we'll see that later in a moment. Now, I'm going to pass. I don't obviously ignore them, but the next sections of the judgment I am going to pass over. There's a discussion about how one should interpret a multi-unit permission, and I've I've introduced, my lords, to the developers' argument that they had a freestanding permission essentially to construct each element of the master plan. And there's a discussion of the Lucas case in that context, and the interpretational argument is rejected later in the judgment. There's then a discussion of the Sage case, which was concerned with planning enforcement action against an unauthorised dwelling house, and a discussion of Lord Hobshouse's well-known dicta regarding the need to complete a development in every aspect. And that discussion is there, just to inform particularly my lords and my Lord Henderson, that because in Hillside the authority had argued that inability to complete the original permission meant that all development already done under it was unlawful, and that was rejected. But in my submission, it's, for our purposes, it's sufficient to turn to a very neat summation at paragraph 68, which is page 105, and picking up the words in summary: failure or inability to complete a project for which planning permission has been granted does not make development carried out pursuant to the permission unlawful, but in the absence of clear express provision making it severable, a planning permission is not to be construed as authorising further development if at any stage compliance with the permission becomes physically impossible. And by compliance is meant full compliance. And that, in my submission, logically, it applies just as much if what makes things physically impossible is a partially built out other permission or a wholly built out other permission. So two physically incompatible permissions for the same land mean that both permissions cannot lawfully be completed in accordance with the permissions granted. And as I've said, but now I make it good, a point of some potential importance, at least to our case, is illustrated by the facts in Hillside. Because even though it might be possible, in fact it clearly was possible, to build out some more of the original permission there, so as a matter of theory, build out some more of an already begun permission, the fact that the incompatible permission and what's been built under that makes it physically impossible to complete the original permission. It meant no more development could lawfully take place under that original permission. And I refer again, I've taken my lords to it, to the developer's argument of paragraph 18, which was rejected at all levels. The reason that's a relevant feature of the rule, which I believe is still rightly referred to as the Pilkington rule to our facts, is because it was rightly common ground below, and I'll come on to explain this, that as soon as the 2021 permission was begun, it would be physically impossible to complete the 2017 permission. And so with my submission, it follows from that beginning the 2021 permission would have meant that nothing more could lawfully be done to build out the 2017 permission. Now,
is that actually common ground?
well, it certainly was below, and I'll take my lord to it in due course, if I may. I have a point to take my lord to it, if that's acceptable.
Well, just to clarify, it was common ground below before Hillside and the Supreme Court came out. In light of Hillside, there's a rather more nuanced approach now in my submission.
Well, you'll no doubt tell us about that later on.
Yes, ma'am.
I'll wait for my learned friend submissions on that, of course, my lord.
Right.
Now, the judgment in Hillside then proceeds to discuss the need for departures to be material.
Yes.
There's no suggestion here, of course, that the incompatibility we're concerned with is not material. and it proceeds through other matters that are not directly on point. Now, just by way of just tidy up before I turn to the facts, I set out a run of other legal propositions in my skeleton at paragraphs 24 to 26. I understand none of them to be contentious. They include, I say this particularly for the benefit of my Lord Henderson, they include that where an authority grants planning permission in accordance with officer advice in a report to a committee, as is the case here, the inference is it does so for the reasons set out in that report.
And that's common sense, really, isn't it?
One would think so, my lord. It took quite
Was for that.
yes, it took quite a lot of jurisprudence to get to that point. The second point I draw attention to is that the focus, and this applies, of course, to all administrative law. The focus must be on the authority's contemporaneous reasoning, the evidence that was actually before the authority at the time, and the court should be very slow to entertain anything that is ex post facto or amounts to evidence and reasoning that wasn't before the authority at the time as somehow justifying the decision. And that comes from a housing homelessness case called in any event, none of the propositions I set out at 24 to 26 I understand to be contentious, including regarding the standard of reasoning. So I turn now to our facts, and for this, my lords will need both the supplementary bundle and the core bundle, and I'll be moving between the two. Could my lords please begin by picking up the supplementary bundle at page 6. This is tab 2. This is the letter from the interested parties planning agents that explains the application that was before the planning authority. And I should say we don't need the application form itself. This contains everything and much more. As I said, the application was for a sizable DNO compound and some solar panels. It was in the countryside, and it was explained and justified by this letter on this basis. And I'll take my lords through it slightly laboriously, but I hope fairly swiftly. My lords will see immediately from the bolded words at the top, which is that's the description of the development for which permission was sought, that was on the application form, and of course eventually in the decision granting permission. One will see immediately that the development for which permission was sought was, quote, associated with planning permission reference, and it goes on, and that's the 2017 permission that the authority had previously granted in this location. And that association was clearly an association with that particular 2017 permission solar farm, not some notional solar farm here. And the association is explained in this letter, because as we read down through the words, after some discussion of the history, we then turn the page to find that the development here, and this is at the top of page 7, second paragraph, is being proposed in order to, quote, complete the construction of that 2017 permission solar farm, and to allow it to, quote, release the renewable energy benefits. And what that means is explained further down, because it said that the applicant has worked with various people to quotes, finalise the construction detail of the solar farm, and the means in which the renewable energy generated will be exported to the grid. Now, it's said then that at the time of the 2017 permission, details for connection to the grid were not finalised. Now, certainly, as regards what the planning authority understood at the time in 2017, that's a contentious claim. But anyway, in any event, that's what's said in the letter. There's then as I say, there was earlier an explanation of planning history, and that's at page 6, and we come back to it here. What the applicant had done was apply under section 73 of the Act for what's often referred to as a variation permission. It's a standalone permission, but a permission that would vary the 2017 permission and allow for a DNO compound within it. That had been applied for in 2019 and had been quashed. But they're saying this application was very similar to that application for the permission that was quashed. It was quashed in 2020. And just...
Had the quashing... It hadn't yet happened, had it?
No, not quite. By a matter of perhaps a month. Yes. Yeah. Indeed. There's. It's quite clear. And this is a point that goes to my my consequent submission more than my incompatibility mandatory material consideration submission, but it's quite clear from page 6 that they say it's our client's intention to lawfully implement this planning permission on receipt of the approval of the remaining conditions under consideration. So they're quite clear that they're going to proceed with the 2017 permission solar farm. And just going forwards in time now, not in the letter, of course, but in summer 2020, the applicant interested party do begin the development under the 2017 permission. And it's then, of course, about a year later, and we don't know what they'd actually done by May 2021. It's about a year later that the authority grants the permission under challenge here. We can note, please, also another point. Similar things are said at various points, but at the page 8 in the supplementary bundle, the letter is clear. It says the application ties into and is consistent with the solar farm development which was previously granted planning permission in 2017, and it gives some examples, and they now, of course, I'll come on to that's actually wrong. Now, just pausing at this point, clearly the vital context and the justification for the application here was the 2017 permission solar farm. The site layout for that, and could my lords now...
So we're now coming to the 2017.
We're now coming to the 2017. I'm going to ask my lords, could I, if it's possible, if my lords could leave the supplementary bundle open here, because I'd invite my lords to turn up these big plans. I hope it's not confusing. I've given them, I've lettered them A through to I, so as not to add another set of numbers. At D, my lords should see the site layout plan for the 2017 permission. And as I say, this was a site of some 72 hectares. And the site layout and block plans for the 21 permission, well, those are at B and C, but they're really best appreciated at C. I should also say that A, the detailed landscape proposals for the 2021 permission is also quite helpful.
So
in fact,
D is the 2017.
D is the 2017.
Shows
my Lord
no
Coulson.
compound because citing was a matter to be approved later.
That's what the IP says. I'll take my lord to what was actually understood at the time.
But that's what the plan shows.
It shows no compound.
It shows no compound.
No compound.
So there are all these panels. The black is showing where the solar panels are to be.
The black is showing where the solar panels are to be, and my lord, looking at the centre of the site, because this is the focus. My lords will see from B, which is the 2021, and C where the 2021 fits. Essentially, it goes in the centre. In the centre of the
So that
site.
cites that. So 2017, the compound is not cited. In the 2021, it is. And the other difference appears to be that there are then some panels to the east of the pylon, which aren't shown in 2017.
Yes, my Lord Coulson. The further point to note though is in the there was no compound proposed in the 2017.
No, because that was going to be done later. That there was going to be a compound because it says so, but it says that citing is to be approved later. That's condition 15.
Well, not, my lord. That's not quite right. I'll come on, but if I may, I will come on to that.
Okay.
In the 2017 plan, my lord can see towards the east this yellow area. It's
which one are we looking at? D.
so that looking at D.
D. Yeah.
There's a yellow area in the centre. In fact, what is almost the very centre. One can see the line running north-south, which is the 132 kilovolt overhead electricity line. And there's a very small
squares,
square.
I think, are pylons.
They are, my lord. Exactly, exactly right. If my lords could focus on that square, which is indeed a pylon that's very central, to the east of that, my lords see yellow. It starts a little bit over yellow. There's a yellow area.
Yeah.
That's a conservation area that was part of the development permitted and important, obviously, for ecological landscape reasons.
And the 2021 shows panels there.
The 2021 shows panels there, and of course it also.
So that's the second point I put to you. So that's right. And you want to come back to me on why the first isn't, as you put it, quite right.
Yes, I am, my lord. Yes. Now, I will. In fact, I'll deal with that. I'll deal with that now, my lord. No question, of course, that the purpose of the 2017 permission solar farm, the whole point of this, was to generate electricity and export it to the grid. But at the time, and what the could my lords please in the supplementary bundle turn to tab 5? That's the decision notice for the 2017 commission. Now, page 13 here, my lords see the wording, the operative wording, begins installation of a ground-mounted solar park to include ancillary equipment, inverters, substation, perimeter fencing, and so on. Now, the substation permitted was merely a 33 kilovolt substation. It was a shed size type item. And that is it's in the list of approved plans. It's the DIS 000 plan, and it's then
So which is that?
it's number
I think
six.
it's the sixth one down.
Number six. It's sixth one down.
Thank you.
And it's then and it's of course then
And do we have that?
we do, my lord. I'll take my lord to it in a moment. It's tied down by condition 2, where it's the plan is actually described in a slightly different way. It's again the sixth one down. Typical single 33 kilovolt GRP housing switchgear, drawing DIS 000. And then there's a condition which is 15, a few pages on, requiring details of the siting of the substation shown on that drawing.
This was a full planning permission.
It was, my lord.
So citing was not, as it were, a reserved matter, but it was in this instance a matter subject to a condition
Yes.
for subsequent submission and approval,
Yes, it was, my lord.
and that was condition 15.
That was condition 15. Yes. And that drawing DIS 00 is the next tab, tab 6 in the supplementary bundle at page 19. And as I say, it's about the size of a shed. I mean, the chalk and cheese from the D&O compound, the subject of the 2021 permission. The reason I said, my Lord Coulson, I needed to just come back and clarify what was understood at the time of the 2017 permission is that certainly the planning authority at least clearly believed that all that was needed to connect to the electricity grid was the shed size 33 kilovolt substation. And we can see that in their contemporaneous reasoning in their reports. So those reports are start at the next tab, tab 8, at page 47. The first, this is there's a first report and then there's an update report. Now, at page 47, at paragraphs 8.31 down, there's a discussion here of what's called an SAS, which was that was a site appraisal study to work out essentially if this was a good site or a bad site for what was proposed. And we'll see, my lords, at 8.32 that the point is made that for a large-scale photovoltaic scheme to be deliverable, it's necessary for the development to be located within proximity to an electricity distribution network. Refers to, where possible, a point of connection to the grid within the application site is desirable, especially when connecting to the 132 kilovolt network, as proposed in this instance. Note, and it says this. That the SAS states an application for grid connection has been made with a point of connection proposed 700 metres south of the site. Now this is the knot in the planning history here. When the application for the 2017 permission was first made, there was a proposal for off-site connection to the 32 kilovolt grid. However, what then happens is that very late in the day, there's a change, and we see that change in the subsequent report, which starts in the next tab, tab 9. This is the update report of June 26th of June 2017, and we see this at paragraph 3.6 down to 3.7. Further clarification has also been received in respect of the substation required in order to connect the proposed solar farm to the national grid. The supporting information originally submitted with the application made reference to a new substation being provided on land to the south of the application site, and it gives a reference back to the earlier report. However, no details regarding its location were provided. The applicant has now confirmed that the substation is to be sited in the eastern half of the middle field of Parcel B, adjacent to the existing tower to connect into the grid. The substation would be positioned as close as practical to the tower, connected via underground cables. As such, and this is the very important point, the only structure required will be a single-storey building measuring 5 metres by 4.5 in footprint, as shown at page 72 of the agenda. Final siting would be determined in discussion with the DNO operator, and it goes on to discuss where the substation building would be positioned. They're talking only about the 33 kilovolt substation. Now, whatever the developer understood at that time, clearly the authority understood that all that was needed was this shed, as I say, shed-size type substation. Now, as I say, in terms of a further bit of history, the developer then applied for a Section 73 permission. That was quashed by Mr. Justice Morris. The developer, after this permission was granted, and after the claimant brought her challenge to this permission, applied for a Section 73 permission to, as it were, fit this permission and the 2017 permission, but with a variation together. That was very recently quashed, again by Mr. Justice Morris, as it happens. I understand, as of yesterday, the authority has sent an appellant's notice seeking permission from this court to appeal. In any event, that's a side point.
Is this all just as a matter of interest, really? Is all this in the short chronology that we've been provided with?
The very latest part is not, my lord, because I prepared the short chronology before Mr. Justice Morris handed down judgment.
Would it be convenient to produce an updated
Of course.
chronology for us, because it will be useful, I think, to
Yes.
to have that with the most recent events in it. It's not entirely straightforward to assemble a clear understanding of the salient events. There have been several claims for judicial review. I don't know whether there were 3 or 4 altogether.
Altogether 4.
4, yes.
4, my lord. The first was to challenge the purported Section 73 permission for a DNO to include a DNO compound that was granted in 2019, and that was quashed by consent in May 2020, I believe. Yeah. The next challenge was a challenge to the discharge of conditions under the 2017 permission, and that challenge did not achieve permission for judicial review. Then there was this challenge, and as my lords will have probably noted, at the very time that this challenge was being heard by His Honour Judge Jarman, the authority was granting another Section 73 permission, which was then challenged, and Mr. Justice Morris quashed that permission by judgment handed down in September. I will update the chronology.
If it's not too much trouble, when you do that, and obviously it should be agreed as a matter of fact between the parties, it would be helpful, I think, certainly for me, and I imagine for my colleagues, 2, if you could identify each claim for judicial review, as it were, by number. So judicial review claim number 1, number 2, number 3, number 4, so that we're of a clear understanding of the
Yes.
sequence of events.
Yes.
I'm sorry to put you to that trouble, but I think it will help us.
Of course, my lord. Of course.
Thank you.
Yes.
Yes, you were telling us about.
I was just going. Sorry.
Well, I've got open in front of me page 78, and you've been looking at the update report. I don't know whether you were going on from there to the next.
I was going on to my next point. So
Yes.
I hope 78. I hope my lords have the point that the authority at least understood that all that was needed in 2017 was this 33 kilovolt substation.
Yeah.
Now, back into the chronology. At the time the application came to be decided by the authority in May 2021. Of course, we know the interested party had already started to build the 2017 permission solar farm, and we know the planning authority was aware of that, and this is in the core bundle, and this is why I said my lords can now put those plans to one side.
Right.
This is why I said it might be necessary to have the core bundle and the supplemental open at the same time, because the core, of course, has the authority's reasons in its officer report for granting the permission under challenge. They're in tab 13, and we can see at page 167. The preceding page is the cover sheet, as it were. This is the main officer report to the planning committee. There is an update, but indeed a correction. But this is the main one, and this is where I'll be focusing, because in terms of the reasoning,
Yes.
this is the important one. It starts at page 166, and then at 167 we can see at 3.1 that the authority, and this is the second paragraph, the authority are clearly aware that development has commenced under the 2017 permission. We see that in that second paragraph. We see also an example of the word implementation used in what I say is a confusing way. What the report doesn't tell us, though, is what had been done either in summer 2020 when the start was made, or more pertinently by the time about a year later that the authority was actually considering this in April, May 2021. Now, we're going to be able to put the supplementary bundle away just after drawing attention to one point back in that application covering letter, if I may, and it's this point. It's at page 8 of the supplementary bundle, and the planning agents, about the midpoint of that page, they, of course, they advance the proposition or contention that the proposals are considered to comply with the relevant policies of the Test Valley Borough Council Development Plan, and they also refer to a number of material considerations, including paragraphs within the National Planning Policy Framework, which are strongly supported, and they say planning permission should therefore be approved without delay. So they're quite unambiguously asserting compliance with development plan policy. Now, that matters very much, and we'll put the supplementary bundle away for now, please, my lords, because turning back to the core bundle and the main officer report, page 182, we see a perfect encapsulation of a very important, well, it's in my submission, a very important development plan policy, because the development plan policy matrix here for this
So
development,
which page you on?
page 182 of the core bundle, my lord. So we're in the main officer report,
Yes.
paragraph 8.3.
Yes.
The development plan policy matrix here included an important policy restricting development in the countryside. It's called policy COM2. And as I say, this was a countryside location. And so far as material, the policy was that permission for these proposals, which were not, they weren't a use that the policy listed as appropriate in the countryside. Permission for these proposals would only comply with that policy if they were, quotes, essential that the proposals be in the countryside. And we can see that very neatly set out in paragraph 8.3 of the officer report. And of course, the interested parties, planning agents, no doubt knew of that policy and said what they did with that in mind. Now, the crux of the authority's reasoning as regards that policy, and I say very important part of their reasoning for granting this permission is down the page at 8.6. And they say this: the applicant has worked with technical partners and various specialists, and they list them, to finalise the construction detail of the solar farm and the means by which the renewable energy generated will be exported to the local electricity network. It is proposed the renewable energy generated by the solar farm will connect to the 132 kilowatt overhead line which crosses the Woodington site, and this, given the principle of siting a solar farm in this location, had previously been established by the original grant of planning permission, which has already been implemented, and the current proposals ensure the site can function. It's considered it is essential for these proposals to be located within the countryside, and as such, the development is considered to accord with policy COM2 of the local plan. Now, a few points about this. First, when the report talks about the solar farm, paragraph 8.6 and elsewhere, it's clearly talking about the 2017 permission solar farm with which the application was expressly associated, not some notional solar farm here. And the same is true when it talks about ensuring, quote, the site can function. It's clearly talking about the 2017 permission solar farm, not some notional solar farm. And we can see that there are various points, but we can see this very clearly, for example, further. At page 197 in the core bundle, there's paragraph 860.
Yeah.
It starts by commenting on something that some objectors have said. Comments have been received in respect of the 2019 Section 73 permission.
This, just to pause for a second so that we can orientate ourselves in the report. This seems to pick up, doesn't it, the objection which is summarised at paragraph 613 on page 179.
Yes.
Whose objection was that?
I can't say on my feet, my lord. I'd have to check. I'm also.
Was it Mrs. Fiske's?
Again, I have to take instructions.
Yes, of course. Well, don't attempt to do that now. It perhaps goes back to our request at the beginning. But all that we need to have in mind, I think, for the moment is that what is said by the officer at paragraph 860 appears, as I read the report certainly, to relate back to the summary of an objection set out at paragraph 613, which is headed procedural error. That's the common heading for those two paragraphs.
It does appear to, my lord. I should have said so earlier. Mrs. Fiske's husband, Mr. Fiske, also made objections, and I'll certainly, in answering my lord's question, I'll treat them.
They were separate objections, were they?
They were separate objections, but I'll try to ensure I capture those as well.
It's a bit of a clue. At 6:13, it refers to our client, a JR challenge by our client.
Yes. Yeah.
Thank you.
Now the point I was making about 860 is this where we pick up from the words however. So this is the response to the objection. However, planning application, and this is the 2017 permission, is an extant permission which provides the solar farm which the substation proposal will connect to. This remains unaffected, and so on. So it's absolutely and clearly this is an important point for my case. Absolutely clear that when at paragraph 8.6 the authority says this is why this application is compliant with our restrictive countryside policy. It's because they're saying it will ensure the 2017 permission solar farm can connect to the grid, not some notional solar farm.
Could we just go back to 8.6 for a moment?
Yes.
The passage you read to us,
Yes.
Which states, given the principle of
Yes.
siting a solar farm in this location, it should say has, I think, has previously been established. What do you understand that to mean?
Well, read in the context, my lord, it means the principle of citing the 2017 permission solar farm.
That's not what it says, is it?
It's.
I mean, it wouldn't need to. It wouldn't. Would it need to say that? Because actually, as we've seen and you've confirmed, the 2017 permission was a full
Yes.
permission. The language used is given the principle of citing a solar farm in this location has previously been established. So it's the understanding of that I think we're quite keen to take from you.
Well, clearly the first clause of that sentence talks in terms of principle, and I would accept. I cannot say, and I don't say, that picked up out of context in isolation, that can be read as anything more than the principle of a solar farm here. However, as ever, one cannot take out of context or take in isolation. And here, one reads on to the words which has already been implemented. So now, looking at the next, and although there isn't a comma, I would say, well, that's a further clause there, which has already been implemented. Now the author is talking clearly only about the 2017 permission solar farm specifically, and then reading further, and the current proposals ensure the site can function. And in the context, those words ensure the site can function. Context, of course, including what's said in the application letter and what's said elsewhere in this report, and I've taken my lords to 860. That is referring specifically, it's an odd formulation, I accept that, and that's why I address it, but it's referring specifically to the 2017 permission solar farm. Now, my lords, and as I say, this is why I made a point of going to the words of the site, and my lords will have been clearly struck, as I was, by the need to consider those words of the site. But in the context, that is what they mean in my submission, the 2017 permission solar farm. Because it wasn't saying everything in the application and everything in this report, wasn't saying that it would allow a notional solar farm to function. And these words, solar farm, in the paragraph read in the context of the report as a whole, they are referring specifically to the 2017 permission solar farm.
Right.
And my lords will look in vain for anything in this report, that says what matters in policy terms is that these proposals will allow a notional solar farm here to function, or anything along those lines. And bearing in mind the application before them, explained in some detail in that covering letter, is all about the particular 2017 permission solar farm. That's the context, and there's no divergence from that justification in this report.
Do we get any help from the fact that in 8.6, in the previous sentence to the one you've been taking us to, the words "the solar farm" capital S capital F suggests that's a defined term referring to?
Well, I say we do, my lord.
Yeah.
Yes, and it's the 2017 permission solar farm.
Well, I mean, I would certainly have no problem accepting that in relation to the reference to the solar farm as a defined term, but then when it says given the principle of finding a solar farm, is little s, little f, has already been established, that does suggest looking more broadly at the underlying principle rather than the particular situation on the ground.
That taken in isolation, yes, it does, but then put back into context and coming to the absolute crux of the reasoning of why policy compliance is achieved. It's those words at the end, which has already been implemented. Now, those words immediately call into question in my submission whether it is right to even start to begin the words at the start of that sentence as simply talking about principle, because it's not that something notional had already been implemented or correctly explained, begun. It's the specific permission that had already been begun. So it's
Not sure how you can have beginning notional works.
Exactly, my
Speaking
lord.
as a builder.
Exactly, my lord. And although
The words of this sentence are pretty clear, and your submissions, we understand, certainly speaking for myself, I understand your submissions. I think we're getting a bit close to passing this as a classical text, which I'm sure the officer would not want.
No, I'm sure the officer would not want. And just to wrap up there, I would submit that the first part of that sentence is somewhat loose language, but it's all ultimately concerned with the specific solar farm.
I dare say I'm being very slow. Forgive me. You criticise the word "implemented" in that sentence. What do you say it should have been? What should have been said there?
My lord, it's only because I just flagged that.
Yes. No, I understand the distinction.
Begun. It should have said begun or
begun. So yeah. So that you would accept implemented meaning begun.
Meaning begun.
Yeah.
Yes.
Right. Thank you. That helps me.
Lord. Thank you. Now,
want to take anything else from the report?
From the report, well, I believe that we've already had. It's a little bit odd. I say not odd. No. If it had been written as a classical text, as my Lord Coulson refers to, then there might well have been a part of the report that says I'm going to define solar farm by reference to this, as my Lord Henderson said. But
to help us, you would, and we needn't go and look at the authorities unless you want to do that. But you would invite the court to adopt the approach which this court has endorsed several times. Perhaps encapsulated, for example, in the Mansell case.
Yes.
a reasonably benevolent approach to the reading of an officer's report.
Of course I would, my lord. And I say here, a benevolent approach is one that fits entirely with my
Yeah.
my interpretation. The further point I'd invite my lords to note from this report is that there's no suggestion in the officer report that the countryside policy essential test would have been met had the proposal been considered as a standalone item, not associated with the 2017 permission solar farm. No suggestion of that. Now, as my lords know, because I've already shown my lords, in fact, contrary to the justification that this would allow the 27 permission solar farm to function, it couldn't because they were incompatible. We've looked at the two very obvious on the plans incompatibility, the D&O compound clashing with the area of solar panels to the west of the overhead line, and the solar panels part of this application clashing with the landscaping area to the east of the overhead line. The only other point, but it is a point to note, is that the 33 kilovolt substation had in due course, as envisaged by condition 15 to the 2017 permission, been fixed as to its location, and that is at in the big bundle of plans, although that's item H. It's a 2019 plan, and my lord swore note, as my lord Coulson pointed out, it's right next to, as one would expect given what had been said in 2017, it's right next to that pylon. The 132 kilovolt pylon is the red dot. Now that is not something that then appears on the 2021 permission plans.
Just pausing there.
Yes.
On your case, if the 2021 permission had incorporated that location and that size of plant room, is that incompatible with the 2017 permission?
That would not be incompatible.
Even though that would have the red square denoting the plant room in what you call the conservation area to the east of the pylon?
No, my lord, the red square is to the west of the start of that conservation area. Could I, in fact, for that, could my lord turn to...
All right.
Could my lord turn...
So it's H, is it?
Mm.
Yes.
It,
Okay, so it's not
yeah.
in, so it's just in land. So you would accept that that's not incompatible, even though it's not shown on any drawing?
I would, my lord. Could I, because I want to make sure I'm taking a potential point against myself, and make another point. Could I ask my lord to turn to A, which is the detailed landscape proposals for the 2021 permission. There is at A this very faint dotting that looks quite. It's hard to say because it's not quite in. It's not actually in the position of the.
It's not. It's to the northeast.
It's to the north, but
of the pylon.
It appears.
But even if it were, even if it weren't, but were, as it were, not quite due east, but almost due east of the pylon, it wouldn't bump into any of the arrays of panels. Whether there has to be some, for technical reasons or engineering reasons, some clearance between the building and the array next to it, I don't know. But physically, it would seem, as it were, to the naked eye and to the untutored eye, as if you could get such a building in there without bumping into the solar panels.
It would, to my untutored eyes here as well, my lord.
But
yes.
I mean, I don't know the engineering of this, so whether an engineer would say, "Ah, yes, but you need to have such and such clearance," I don't know.
Well, my client probably would know actually, but the point, the other point that I'd like to draw my lord's attention to on this A plan,
Yes.
and it's helpful particularly to have it in A3 because it allows one to clearly read the words that are more or less in the middle of the page, which they say extent of possible extension to proposed conservation area required to make up permitted area due to amended solar panel layout. Now that plan, not only was that before the authority, but that plan was actually specifically attached to the update report. This is core bundle page. It specifically attached to the update paper that starts at core bundle page 202, and it's explained. One sees at page 210. There's an amended recommendation. And that includes a new condition 2 with a list of plans that refers to this drawing by number. And I draw attention to that because it is clear, albeit one might have needed to look at it in A3 or blown up, but it is clear that this document, unlike, it has to be said, the application letter, but this document is specifically flagging up in my submission that there is incompatibility between the application for the 2021 permission and the 2017 permission. That's why they're suggesting a change regarding the landscaping area.
Sorry, I'm being slow again. I'm sorry. It's referred to on which page is it?
In the update report.
Yes.
So, well, it's said, and this is it's just in the amended recommendation.
Yeah.
And we now
If you could just give me a page number.
page 210 in the core bundle,
Yeah.
and then over the page there's then the recommendation doesn't set out the list of all the plans. Sorry, all the conditions. Apologise.
No, but it lists the plans.
It lists the plans, and this one follows.
Yeah. Which is
H05 357_50 revision A.
50 revision there. Yeah.
Yeah. And clearly, my lords, all of the plans and drawings were before the local authority anyway, but we have this specific one.
So this,
Where's this referred to in the report?
I'm not sure.
Because you're making what I
Yes.
noted down to be a new submission. That this drawing drew attention
Yeah.
to incompatibility.
Yeah.
That's, I think, a new submission.
It is a new submission. Yeah.
And so we need to know how that hangs together. If this was referred to in, you said, the addendum report.
Yes. Well, it's attached to the addendum report.
yeah. So
I don't believe.
So the picture we're getting is this, is it? That the members had an update report.
Yeah.
Which drew attention to drawings in the way that you've demonstrated on page 211.
Yeah.
The drawings were available in the committee room.
Well, this one certainly was. Sorry.
Is that right?
Page. Well, this one must have been because what the office page 211, my lords. What the officers do is they underline what's new, and new condition 7. This is underlined.
Oh, so that's it's referred to as the landscape
Yes.
maintenance plan, is it?
Well, it it's, well, no,
Is it
actually,
the landscape
sorry, no, it's
proposals?
it's what follows after. It's the detailed landscaping proposals, but they're
Right, so it's not merely in the list, it's actually drawn attention to in the text.
it's drawn attention to in the text. In this is a suggested condition text, and then
And if one went to the drawing, which was before the members
Yeah.
in the committee room, one would see the notes that you've drawn attention to.
one would see the note I draw attention to. Now, I don't set actually this note is sits somewhere down the pecking order because what I say is it's so obvious, just so totally obvious, picking up the plans that there's incompatibility. One doesn't need a note
So
to
one
tell
could,
one that.
no competent member could miss the incompatibility you're submitting.
I'm submitting that.
You
Well,
are.
and no, well, my lord, no competent authority, because we have to, in my submission, we do have to, for these purposes, take the authority as a whole, as it were.
But you're saying the incompatibility was obvious.
I am. But just obvious on the face of the plans, without any need for any technical knowledge, as my lord Coulson pointed out, one sees the D&O compound sat in an area that's marked for solar panels under the 2017 permission, and the solar panels that are part of the 2021 permission sat in an area that's marked for landscape, for the conservation area. And the incompatibility meant that the development could not, contrary to the justification advanced by the interested party in its letter and the planning authority's reasoning, accepting that justification as making the proposed development essential in the countryside and so policy compliant, well, it could not ensure that the 2017 permission solar farm could function, as both could not be built out lawfully. So it flatly contradicted the authority's reasoning for finding policy compliance. It contradicted that key reason behind the grant of planning permission. It was, if one likes, my lord, it was a basic and fundamental mistake of fact. It goes a little bit further than that, and I think than simply that one couldn't build both of these out lawfully, the 2021 permission and the 2017. And my learned friend says he's going to come back to this, but I said I'd come on to it. It was common ground below. Could we please turn in the supplementary bundle to the transcript? This is page 211 of the supplementary bundle. This is my so these are my learned friend Mr. Green's submissions.
I'm very sorry, Mr. Burton, I missed the page.
211, my lord. Supplementary bundle 211. At A, first, proceeding down the page, we see my learned friend accept. Certainly, if the substation permission, so that's this 2021 permission, was begun, that would render it physically impossible to carry out the original permission scheme in its original form. And then there's some questioning, and then that is repeated later down the page at around D. Once the substation permission works were begun, it would no longer physically be possible to carry out the original permission. And as I hope I've shown, my lords, Pilkington, as explained in Hillside, is all about physical impossibility, and the position, as I say, could not be clearer. And that was common ground, that physical impossibility. Simply with the beginning of the 2021 permission, the 2017 permission could not be completed. And so applying the rule in Pilkington as confirmed and explained in Hillside, if one started building the 2021 permission, that would mean no further development could be done under the 2017.
Yeah.
If one started building it,
Yeah.
but only started
Because
building it.
Pilkington and Hillside are about cases where the works were done pursuant to the original, or should have been done pursuant to the original permission. In Pilkington, it was done subject to the later permission, which meant the original permission couldn't be done.
Yes.
And in Hillside, they didn't comply with the original permission. So on the facts, this is a different scenario, because here, on the facts, the works have been done pursuant to the original permission.
Yes.
So that this is predicating a condition if the substation permission, the 2021 permission, was begun, if works were done pursuant to that,
Yes.
then you couldn't, I mean, for example, if you started to build the compound, you couldn't put in the panels. That's the simple point.
That's the simple point.
But that's all if.
Yes, it is. All if.
And the facts remain as they were before His Honour Judge Jarman. That hasn't happened. In fact, that they haven't started building under the 2021 permission. Is that correct?
I don't know. We could try to find out. I don't know.
I think that was it clearly was. I think it's in the judgment actually. He says that.
So certainly.
Well, we'll take instructions on
Yes,
that.
I mean I think we've assumed that remains.
Yeah. In any event, what that means, and I should say what that means for my learned friend's skeleton argument, and I could I just turn my learned friend's skeleton argument up for this point, the paras 32 to 33.
You want us to keep open the transcript?
No, my lords, no, thank you. My learned friends say a couple of things at 32 and 33, and I want to deal with the factual contentions being advanced here. Now, I'll deal with them in reverse order. The first thing they say is that at 32, works to implement the 2017 permission took place in June 2021. I could say implement, we mean begin. They say those works did not involve development within the area of the 2021 permission. No further works under the 2017 permission took place prior to the 2021 permission being granted. I'll come back to that contention. And then at 33, they say this means various things. Now, B and C there, B and C cannot stand the clear concession below that I've just taken my lords to, that if and indeed when, but if and when development under the 2021 permission was begun, simply begun, it would be physically impossible to complete the 2017 permission. My learned friends are advancing positions that are at variance to that in those paragraphs, I say.
So you say B is wrong?
Well, because B is wrong because it's pregnant with the point that it will require something more than just beginning the 2021 permission to render it physically impossible to complete the 2017 permission.
Your submission, as I've understood it, is that at the point at which an incompatible planning permission is I think I'm using the word correctly, implemented, because the development under it is begun. Yes. At that point, notwithstanding that there isn't a physical clash, if you will, on the ground, to continue any works under the previous permission, the 2017 permission, would be unlawful.
Yes.
Whereas you're saying that B here implies something different, which is that you can carry on until the physical clash would be the next thing that happened.
Yes. And it implies something different on the facts, which is different from the concession.
Yes. I mean, I'm sure that in the passages from Hillside that you took us to, that the answer to this point is crystal clear. You don't have to take us back there, but I think that's where I would go looking for the answer to that point, and it must be there.
It is there, my lord, and the simple point in Hillside, which is why I took my lords to paragraph 18 in Hillside.
18, is it?
It was that in Hillside it was physically possible to build more.
That's
of the
right.
original
That's
permission.
what I've got in mind. Yeah.
Exactly, but the Supreme Court said no matter, because you cannot complete the original permission. It's physically impossible to complete the original permission. You must stop there.
Because they had not complied with the original permission from the outset. That was the problem in Hillside. They had departed from the works for which they had permission in 1967.
They had.
I mean, the thing went wrong from the start.
Yes, because.
And so that's why it became, in that sense, physically impossible.
Yes, with a caveat, my lord Coulson, which is that the reason there was departure so far as material to the ratio in Hillside is that other inconsistent planning permissions had been granted and had been used, and the dwellings permitted by those inconsistent permissions had been built out, which then meant that physically, just looking at a plan in the Hillside case, one couldn't build what was shown on the master plan.
The whole thing had become tainted.
Sorry, my lord, I didn't hear.
The whole thing had become tainted.
It had, and that physical impossibility lies at the heart of it. But this point that I come back to, one has to, in order to fully understand and reflect the rule in Hilkinson and Hillside, understand that by physical impossibility is meant the physical impossibility of building out all of whatever the permission is concerned, all of the permission in accordance with its terms. And it's absolutely not the case that because there are parts of a site that are still open, as it were, and one can build out further bits of the permission.
So your primary contention here, I think, is, as I've understood it, that at the moment at which the developer began to build under the 2021 permission, he would have lost the entitlement to continue to build under the 2017 permission.
Indeed.
That's the proposition.
Indeed, that's the proposition. Yeah. Now I said I come back, my lord, to the other point, that's the factual point that's made at paras 32 to 33 of my learned friend's skeleton argument, where they say that no further works under the 2017 permission took place prior to the 2021 permission being granted. Now, it's a surprising submission because there's no evidence for that, and all that there was below, and indeed is on appeal, is an absence of evidence as to what had been done under the 2017 permission. I say in any event, and I'll come on to this, but in any event, these are all they're all red herring submissions anyway, because they're not something the authority in any way turned its mind to at the time. But that submission at 32 does offend basic principles, Latin Marshall principles, I noticed it only recently. I discussed it with my learned friends yesterday, and I said I don't want to make too much of this, but it's not disputed that there was no evidence to support that below, just an absence of evidence. It won't surprise my lords that I say my client can't say one way or the other what's been done under the 2017 permission, because this is a private site. If I may, I'll give my lords, without actually going to them, a flurry of references to make good my submission that all the position below was, and indeed remains, that we just don't know what exactly the developer had done under the 2017 permission. First of all, judgment paragraph 4. Secondly, my learned friend's skeleton below at para 20, and this is at core bundle page 71, where they actually talk about a possibility of the interested party could remove the development carried out under the original permission and then begin the substation permission, which very much conflicts with what's said here. And then in the transcript, SB 186 at E, where I say I don't know.
Sorry,
186 at E, I say I don't know what had been done to begin the 2017 permission. SB 211 at B, my learned friend Mr. Green says if the substation permission was begun, there's no evidence to suggest that what has been done under the original permission would render it physically impossible to carry out the substation permission. So it's a no evidence submission, as opposed to there is evidence that they haven't built on the 2021 permission land. And then I SB 229 D2F, where I emphasise the lack of evidence. In any event, so this point by which my learned friend seemed to set such store that the works, it can be definitively said the works under the 2017 permission didn't impinge on the area of the 2021 permission. We just don't know. There's no evidence for that. But I say in any event, it's a red herring. Certainly means that paragraphs A and D at 33, which are predicated on that, cannot stand. In terms of the facts, this is the number there. As I've said, there was nothing whatsoever in the authority's contemporaneous reasoning to the effect that, well, the permission being sought here isn't necessary to make the 2017 permission solar farm work. To the contrary, for the authority it was vital, it was absolutely necessary and fundamental to it passing policy. There was nothing along the lines of, well, these two are incompatible, but we should nonetheless grant permission in the expectation that some reconciling application will be made. No reasoning whatsoever along those lines, no reasoning that the incompatibility wasn't a problem. Rather, the authority simply did not grapple with the incompatibility. It didn't ask any of those questions, and it didn't do so because, and I say, on the face of the plans, quite inexplicably, it just missed the incompatibility. If I may, at this junction, and I will come back to this, but just make the point that the learned judge below, despite my repeatedly emphasising the importance of the authority's reasons for deciding the essential policy was met, and going back to that paragraph 8.6 in the report a number of times, when considering this question, was the incompatibility a mandatory material consideration? When the learned judge comes to tackle the key issue, mandatory materiality, at judgment 24 onwards, we have a very basic form of summary of my submissions at judgment 27, where there's a reference to essential, but then nothing there's no wrestling at all in the judgment with the authority's reasoning for deciding the essential test was met. No wrestling with the relevance of that to the question of mandatory materiality. Yes, I did make the submission more than once, and the judge told me to stop repeating it, but I made it because of my great concern that the judge was being led away from a proper focus on that contemporaneous reasoning to the, quote, interested party had other options argument that my learned friends advanced that formed no part of the reasoning at the time or the evidence before the authority. And my fears in my submission did prove justified. Now, as I say, there is nothing whatsoever to suggest that the authority did what it ought to have done and actually appreciated the incompatibility at a decision-making level, despite its obviousness on the plans. I draw attention to a point that might be neutral, it might be against me, it might be for me, but I drew attention to it below, and I should draw attention to it here before my lords. In the it concerns what the conservation officer consultee or consultees had said, and it's in the main officer report at core bundle, page 171. If I could ask my lords to just turn to that, please. And the conservation officer's consultation response is set out here at 5.7. And reading to the word, permission for a solar farm in the current location was granted under application, it gives the reference, see previous comments. This application relates to a small section of the area considered under that application and is for various amendments, including additional solar panels and a substation. Now, it might be that the conservation officer had understood that there was incompatibility here. It might indeed be that the conservation officer had actually thought this was an application for a Section 73 permission, potentially. But in any event, in the decision-making part of the report, which comes later, I've already taken my lords to. There's no advertence whatsoever to an appreciation of the incompatibility. There's no indication the decision makers had it in mind, and as I understand it from my own friend's skeleton argument at paragraph 44, they accept that there is no evidence of consideration of incompatibility. They term it inconsistency, but just finally on the facts, a handful of further elements of the factual matrix.
I'm just looking at paragraph 5.7, which you very fairly drawn attention to. No reference to a Section 73 application there.
No.
It's simply it's a reference to various amendments.
Yes.
Including additional solar panels and a substation. It doesn't go any further than that.
It doesn't matter. No.
And that's not picked up later, I don't think, is it?
No, that's the only bit of text that I can identify in any of the reports that might be said to reflect some knowledge within the authority that what was proposed under the 2021 application was different and inconsistent, to use my own friend's words.
I don't know whether there's any force in this point, but let me ask you the question in fairness. There's a lengthy planning history here and a succession of applications are made. It might be said, I suppose, that the developer doesn't go asking for planning permission for that for which he already has permission, and therefore there's inherent in that exercise, implicitly inherent in that exercise, the concept of difference from what has already been granted planning permission. I mean, that perhaps is just a matter of common sense.
Yes. as I say, I'm
But you
drawing-
say that doesn't affect your argument.
no, I'm drawing attention to this in case it might be against me.
Yes, yes. No, you've done so very fairly.
And
Yep.
I say it isn't against me.
No, I,
Because there's just reading the report as a whole, it's clear that reminding ourselves this represents the reasoning, as it were, of the planning committee. The planning committee just missed the incompatibility.
no, it's very fair to do that. Thank you.
Anyway, just wrap up under the facts, my lord.
Mm.
A handful of additional points, I think 3.
Just give me a moment, Mr. Wynn. He's still reading. He's taking quite a long time. He's got to finish up.
Mm.
He said he's got to deal. He wants to go back there outside and he hasn't done at all with the unfairness.
No. I think it would be reassuring to know that you're on course to finish at or about the midday adjournment. Could you just give us some idea of how things are going?
I'm afraid I can't give my lords that assurance. Sorry, my lords, because I fear that I've got more like an hour to go.
Well, I think we're going to have to, in fairness to the other side, we're going to have to take a view about that. It's now nearly 20 to 1. I think if we came back at 10 to 2, we could then give you until 2:30.
Understood, my lord.
Okay.
I've got a meeting after, but you probably have too, so
You have to stop when?
20 to 5 at the latest.
Well, I think we should envisage that we'll stop at 1 o'clock, come back at 10 to 2, and give you until 2:30, which is another 40 minutes. That effectively gives you an hour from now, from this point, which, given that this is a day hearing, is, we think, fair. I'm happy with that.
Because you will have had over 3 hours then.
I will, my lord.
So press on until 1, find a convenient moment to stop round about then, and then we'll come back in any event at 10 to 2, and you can run on then till 2:30 if you need to do that.
I'm very grateful, my lord. I may go very quickly through my ground 3, and I might
Well,
even.
to help you, what you've still got to cover.
Well, I need to finish the factual matrix, my lord.
Yes.
And then I should. It should actually go really rather quickly under
Yes,
round
I mean,
1 and 2
your
once
next-
I've done that.
You've done Hillside.
I've done Hillside. Next, if I just finish the facts,
Yes.
then I'm going to go on and further elaborate where I say the judge went wrong. But I want to pick up the specific
Yep.
case law regarding what is mandatory material in the case of
Yes.
incompatible, inconsistent.
And if we're coming back to the case law
Pilkington.
and Pilkington and etc., one technique would be to give us the references. You don't have to take us to all the references, so you could give us the references, and we will reassure you or assure you that we will carefully read those passages.
I'm grateful, my
That
lord.
helps you.
I will do so. I would have done so in any event. It's only Pilkington that I'm going to spend any time on in the authorities, if I can reassure my lords. And I do understand. Obviously, I understand. I need to stay within a time budget, and I'm very conscious of the day's listing, and I'm grateful for my lord's indulgence.
No, but thank you very much.
So the first, sorry, I'm wrapping up under the facts, a handful of additional points. The solar panels and the landscaping of the 2017 permission that the 2021 permission obviously clashed with, they were part and parcel of the operative, what's called the operative part of that 2017 permission. They weren't merely something tied down by conditions. And I took my lords to the first page of that 2017 permission at SB 13, where we see the operative wording. So that's the first point. And equally, the 33 kilovolt substation was part of the operative wording. The second is that the planning authority had been busily engaged, very actively engaged with the 2017 Permission Solar Farm since it was granted in 2017, due to, first, its grant, albeit unlawful, of a Section 73 variation permission in 2019, which was then quashed. Then, because it had been discharging pre-commencement conditions and other conditions to the 2017 permission, which, as my lords know, the claimant challenged unsuccessfully. That was going on over 2020 and 2021. So it was not in any way as if this permission had fallen out of its working memory. Not at all. Been very firmly in mind, and there was in fact there was an overlap and a commonality between the case officer who dealt with this application and several members of the planning committee who resolved on it, and that prior history. I'll just give my lords a reference in the transcript. I won't go to it, but I set all this out in some detail at SB 203 A to F below. And the third and final point regarding the factual matrix is that the 2021 permission was granted without any so-called pre-commencement conditions. So it could be begun the moment it was granted without the need for any discharge of conditions process beforehand. So that concludes the run through the facts. And as my lords know, I say, on those facts, not least the justification for the application and the authority's reasons for finding policy compliance and so deciding to grant that the incompatibility was a mandatory material consideration, and the authority's failure to have regard to that means the permission should be quashed. And I say the same is true of the real risk of a breach of planning control. Now, I'm going to come on, and I should be able to make some meaningful progress. I'm going to come on now to the areas of legal principle and their application where I say we actually see the judge go wrong, in addition to the overarching point that the judge went wrong in the application of the Samuel Smith test under my grounds 1 and 2. And the first area, as I introduced at the outset, concerns what is material in the planning context. Now, I took my lords to the Westminster and Great Portland Estates case, and I won't take my lords back to that. I do say that the judge construed the rubric relates to the character of the use of the land too narrowly, and that he also missed the exceptions caveat. What the judgment does in relation to what is material in planning terms is the judgment cites the right case, and that which is in Authorities Bundle 7. But the very short point about the right case, and my lords, I'll give my lords the references, we needn't turn it up. The short point about the right case is that where Westminster is endorsed there, which is at paragraph 36 in Lord Sale's judgment, it doesn't mention the exception caveat, and as I say, the learned judge only referred to right and didn't seem to appreciate that there was an exception caveat. Right, of course, the reason right does what it does is it was all about whether a community benefit fund that was proposed alongside, as it were, a wind turbine development was something that the planning authority could lawfully take into account, and they had taken it into account as a material planning consideration, and that was wrong. If my lords turn, please, to the judgment at 24 onwards, where we see the judge's discussion, judgment below at paragraph 24 onwards. See we see it begins. The question then arises, and there's a description of what is material in planning terms, which, as I say, is a reference to, gives a reference to right without picking up the exception that is clearly set out in the Westminster case. And continuing through to paragraph 30, what we see there, and although the reasoning is, in my submission, rather opaque, what the judge seems to find at 30 is that the incompatibility, the fact that the 2021 permission development was incompatible with the 2017 permission, so they couldn't actually both be built out, seems to find that didn't go to planning purposes. Now, I may be misreading that, but that seems to be what the judge is finding. Certainly, if he did find that, that was plainly wrong. Bearing in mind the context, and in particular the justification for the application and the authority's reasons for finding it complied with the essential test, whether it could in fact connect the 2017 permission to the grid as claimed, went directly to planning purposes and the character of the use of the land. So as I say, I do say it appears the learned judge construed those words relating to the character of the use of the land overly narrowly. And if he did, that then infected his judgment regarding mandatory material consideration. And there's also this reference in the first part of the paragraph where he's directly saying, doesn't consider directly saying they were so obviously material as relating to the character of the, he says, of the 6.78 hectares of land comprising the site to which the application related. Now, it looks as if the judge is just focusing on the implications for the character of the use of the land of only the application site, but given the express association with the 2017 permission, the judge had to, my submission, had to look at the whole 72 hectares, and if he'd done so, he would have, of course, had to find that, of course, it went to the character of the use of the land, that this proposal would, as claimed, or wouldn't, rather, as claimed, make the 72 hectare solar farm work by connecting it to the grid. So I make those submissions about one area where I say we actually see the judge going wrong. I now turn to Pilkington, and I'm hoping to get through this before 1 o'clock. Pilkington is the case law, insofar as there is case law, and I accept immediately what I'm going to take my lord to is obvious, that says something specific concerning mandatory material considerations for an authority in the specific case of incompatibility between applications, or, I say by extension, between, as here, an application and a permission. Now, Pilkington is at tab 3 of the authorities bundle, and could my lords please go directly to page 1531. In the report. This is the judgment of Lord Justice Widgery. And I've already introduced through Hillside the facts sufficiently. We see at E down to H, Lord Widgery sets out various propositions, many of which I've already been to, but now I come to the one that is a crucial point in this case. After Lord Widgery makes the point at E that a landowner is entitled to make any number of applications for planning permission which his fancy dictates, even though they may be quite different comparing one to the other, it's open to the landowner to test the market, and that the planning authority receiving a number of planning applications in respect to the land is required to deal with them even though they're mutually inconsistent with one another. And Widgery then says this: of course, special cases will arise where one application deliberately and expressly refers to or incorporates another, but we are not concerned with that type of application in the present case. And proceeding down, he says, in the absence of any such complication, I would regard it as the duty of the planning authority to regard each application as a proposal in itself and to apply its mind to each application, asking whether the proposal contained is consistent with good planning and the factual background against which the application was made. I do not regard it as part of the duty of the local planning authority itself to relate one planning application or one planning permission to another to see if they are contradictory. He says, indeed, I think it would be unnecessary officiousness if a planning authority did such a thing. And please continue, my lords, to read through, but I'm not conscious of time going to read further. Now, in my submission, what Lord Widgery is saying there, it's all obiter because that was not on what the case turned, but what he's saying there is that in the special case, it will, or at least might be necessary to do what he says it isn't generally the duty of the local planning authority to do, i.e. relate one planning application to another or one planning permission to another to see if they are contradictory. Now, I submit that it is clear by implication, he is saying that in special cases, it will, as I say, or at least might, be necessary to check one against the other, to see if they're contradictory. And those words, and that must apply equally to a situation, at least equally to a situation where one has an application and an existing permission, and it must apply, I say, with even greater force where one has an application and a permission that's already been begun, which are our facts. And I say Lord Widgery's words, albeit obiter, were and are correct. I first give an analogy. If for, by way of example, there's a deliberate and express reference to another document in a public document like a planning permission, then one has to read that permission by reference to that other document. And the same goes where an application, as here, deliberately and expressly refers to another document, namely there the 2017 permission. It's necessary for the authority to consider the 2017 permission here. That then applies with particular force on our facts because the application here, through the application letter that I've taken my lords to, explained that the association between the two was so they could, the one could make the other work, and it was promoted on that basis. The reasoning here aligns, I say, on all fours with the Samuel Smith test for mandatory material considerations, with limb 2 of that test, and it also aligns with the principle of reasonable inquiry for a public law decision maker such as a local planning authority. I refer in my skeleton, I won't take my lords to it, to Lord Diplog's celebrated or much quoted words regarding the need for the authority to ask itself the right question and take reasonable steps to acquaint itself with the relevant information to enable it to answer it.
That's the Thameside duty.
That's the Thameside duty, authorities bundle 9, page report page 165 at B. And in terms of what subsequent authorities have said about Lord Widgery's obiter, well, Pioneer Aggregates, whilst it considers Pilkington, is silent on this, so we need not go there. Hillside, though, could I trouble my lords to turn up Hillside? And I said I would come back to paragraph 30 in Hillside, and I would like to do so now. So that's Authorities Bundle 4, page 95 in the Authorities Bundle.
Paragraph
30, my lord,
30.
which is sidelined. And my lords will see Lord Sales and Leggett in truncated form summarise what I've just taken my lords through in Pilkington. And at the end of that paragraph, and I draw specific attention to this, in saying this, Lord Widgery CJ expressly set to one side cases where one application deliberately and expressly refers to or incorporates another. And I do say that that inclusion in the judgment is, well, clearly there's no disapproval expressed in the Hillside judgment of Lord Ridgery's obiter regarding special cases. And I will go further and say that the lack of disapproval, given the specific quote, may be taken as a form of tacit approval. But in any event, the obiter of Lord Widgery is good and logical and in accords with authority, not least the Samuel Smith test. And the judgment below, of course, doesn't cast any doubt on the special cases principle. The judge makes reference to this obiter at paragraph 11 of the judgment at 1 and at judgment page 27. But what the judge does at judgment page 27, sorry, paragraph 27, apologise, and this is the final point before break for lunch. What my lords will see at judgment paragraph 27 is the judge below finds, the judge below accepts my submission that this was a special case as contemplated by Pilkington. The judge says, Mr. Burton submits that the application for the 2021 permission was associated with the 2017 permission was made to ensure connection with the national grid and thus amounted to a special case as contemplated in Pilkington. I accept those submissions. And he then proceeds, of course, to set out my submissions regarding the basis on which the authority had reasoned and essentially in the countryside reasoning and that it should have grappled with the incompatibility. But the judge accepts this as a Pilkington special case, but then fails to do anything with that finding. The judge respectfully fails to grapple with the point Lord Ridgery was making, which is that, well, in special cases, yes, you do. It is necessary to compare the two, and by implication, if there's an incompatibility, have regard to it.
And that's your submission about what Lord Ridgery says.
Of course it is, my lord. Yes, that is my submission.
If we just work through it, this is right, isn't it? Firstly, this is obiter. I'll, of course, accept that it was referred to at Hillside.
Yes.
Secondly, it simply says it's a special case because obviously there's a link. In most cases, there won't be a link.
Yes.
But here there's a link.
Yes.
So that makes it a special case. Doesn't say it's an exception, just says it's a special case. So different considerations may apply.
Yes.
But I accept, of course, at G, he says, in the absence of any such complication, he then deals with the general duty. But at H, that's unqualified. I do not regard it as part of the duty of the local planning authority. That's not qualified at all.
Well, and my lord, I fully accept that my submission regarding the obiter
I was going to
in
say,
Pilkington.
so you have to submit
Yes.
that actually what he's saying is effectively the opposite of that. You're saying that it is the local planning authority's duty in a case where they are associated.
I certainly say in this case, my lord. Yes, I do say that with one caveat, my lord. The reason I say that is because obviously reading the run of paragraphs as a whole, I say that Lord Widgery is on the one hand contrasting the normal position with the special case
Is there
position.
any case where a judge has said if they're associated, the local authority has a duty to see if they're contradictory?
Well, my lord, I am not aware of such a case. If there was such a case, I would have brought it before my lordship.
Because that's quite an important point. Because that
yeah.
on the law, that's the sort of central submission you make, isn't it? Which is why I was quite keen that we got there sooner rather than
Sooner or
later.
later. Yes, I'm very grateful, my lord. I'm not aware of such a case. The caveat I want to make to my submission and make clear to my submission, I believe I have in my skeleton, I want to make it, is I don't say that Lord Widgery is saying in every case where there is a deliberate and express reference to, or to deliberate or express reference to, or incorporates another. I don't say in every case the authority must compare the two, although I do say it's very difficult as a matter of logic and applying basic administrative law principles, Thameside and so on, to see or conceive of a circumstance where it would not be a mandatory step for the authority to take to look.
What we're dealing with is what you say Lord Widgery was saying, and that is what you say Lord Widgery is saying, because you say, well, it's a special case.
Well, my lord, the reason I'm making this caveat is I can't say Lord Widgery here is saying in terms, and I don't say that he's saying in terms that in every case where there is, where an application deliberately expressly refers to or incorporates another, and for application deliberately and expressly refers to or incorporates another could mean, I say, an application or an existing planning permission. I don't say Lord Widgery is saying here in terms that in every such case the authority has to look to that other and compare them. I say that the logic is that they would need to do so in almost every case, in that I cannot conceive on the facts of a case in which it would not be necessary for them to do so if there was such an express reference and incorporation. But I can't push what my Lord Widgery says further than is actually apparent on the page. I fully accept I'm taking it, and I am putting it into the context of the facts of this case, and indeed taking what is obiter and advancing a proposition which is fact specific to this appeal. In any event, that is a convenient point to pause so far as my submissions are concerned.
All right, so we'll come back at 10 to 2, and we will continue, if necessary, to 2:30, hearing your submissions, though you are, of course, at liberty to finish before 2:30, but we will ask you if you would be so kind to draw halt at 2:30 if you reach that point.
Very grateful.
And then turn to Mr. Green. Thank you.
Court rise if able.